as you will see in a moment. And also, oh, there you go. It's not the bit at the very end, it's the whole thing. And also payment of certain funds. What subsequently transpired, indeed was happening at the time, was that the various assets were transferred out to Liechtenstein companies, which held the assets under trusts, and those Liechtenstein companies were in turn under the directorship, sole directorship of Liechtenstein companies. So you had an extra layer of Liechtenstein companies, and then individuals who were directors of those Liechtenstein companies. Orders were made by the court for the transfer of those assets back to Mrs. Akhmedova, or to Mrs. Akhmedova, in compliance with the judgment. And those included orders for the artwork. And in addition to that, following failure to comply with the orders, a freezing order was made by the court against the Liechtenstein trustee companies, together with disclosure relief. And where we sort of join the action is that there has been a failure by the Liechtenstein trustee company to transfer back the artwork in breach of the court order. And there has been a failure by those companies to provide disclosure in aid of the freezing order. And what was then up for consideration was how those orders could be enforced in circumstances where the Liechtenstein courts, for reasons we don't need to go into at this stage, were not allowing direct enforcement of those orders. And that moved on to development of a strategy to bring contempt proceedings against the individuals, just to remind you, who were directors of the sole director company of the trustees. And over to Liz to develop that a little bit.
Yeah, so the purpose of looking into bringing these kind of contempt proceedings against the individuals were obviously to aid Mrs. Akhmedova in enforcement of her judgment. It can be a useful thing in cases where the structure of the asset holding and the jurisdictions involved means that the assets are very difficult to obtain control over. And so what you really want to do is find out who the individuals are at the end of the line, and see if you can exert pressure on those individuals to actually get compliance with your order. There's obviously reputational issues for those individuals, in particular when they're lawyers, as some of them were in this case. And in the Akhmedova case, Mrs. Justice Knowles recognised that when you get orders against individuals, they can have a real practical utility because those individuals have reputations to protect. And even if they're not in the jurisdiction, they're very unlikely to want to be the subject of English committal proceedings or committal proceedings in the BVI or wherever you might be bringing the committal proceedings. And so I think we're going to look at two aspects of the decisions. There are two decisions which you'll see in the paper which we circulate at the end of the week. The first is how do you go about bringing contempt proceedings in England or in the BVI against foreign directors who are non-defendants. And the second thing that we're going to look at is what happens when those individuals, the foreign directors, say that they can't comply with the court order that you've got in England or in the BVI because it would be a breach of their domestic law. So breach of law, breach of criminal or civil law in Liechtenstein. What effect does that have? Over to you, Alan.
Just to perhaps just explain a little bit the interrelation between those 2 points. Once you have managed to find a way to bring contempt proceedings against these individuals, a potential defence that they might seek to raise is that the reason they haven't complied is that it would put them in breach of a civil or a criminal provision in their home state, the state where they have to actually perform the order, and they might seek to advance that defence not in the committal application itself, but in advance of the committal application by seeking to vary the order or set aside the order requiring them to commit that act. And so that we'll be looking at that a little bit later on. Start with the question of how you actually bring the committal proceedings against them. The relevant provision for committal, of course, in the UK is CPR 81 for the purposes of commercial and chancery proceedings. Family proceedings has its own provision, FPR 37, which exactly mirrors CPR 81. In July of this year, both sets of rules, 81 and 37, were replaced. The purpose of it was to simplify the rules on committal, which had expanded over the years to 38 sub-rules within CPR 81, rather a lot. That's been now refined down to 10 new rules, which took effect from the 1st of October 2020. Now, the new rules expressly state that they do not, quote, alter the scope and extent of the jurisdiction of courts determining contempt proceedings, whether inherent, statutory, or at common law, close quote. That's CPR 81.12. Now, that's important because the previous version of CPR 81, 81.4, made it clear that a contempt application may be brought against a director or other officer of a corporate body. Now, you don't have that same wording appearing in the new CPR 81, but given the provision that it doesn't alter the scope and extent of the jurisdiction, one can confidently expect that you can still bring a contempt application against a director of a corporate body that has breached the court order. And indeed, the new rules do make it clear in relation to the wording of a penal notice that it can include wording that brings in directors and officers. So it's pretty obvious that the new rules still allow you to go down that route.
And in the BVI, you'd be looking at Part 53 of the Eastern Caribbean Supreme Court Civil Procedure Rules. CPR 53.4 specifically deals with committal orders against an officer of a body corporate and says that you cannot make such orders unless a copy of the order has been served personally on the officer and the copy of the order contains a prescribed notice personally warning that person that they may be liable for contempt. So it's equivalent to the English rules, really. So in the Ackmordova case, there were 4 steps that we needed to do to bring contempt proceedings against the individual directors. And we're going to just run through those now. So the first was we needed to add the individual directors to the penal notice. Second, we needed to serve the freezing order with the penal notice. Thirdly, we needed to bring the contempt proceedings, and then fourth, serve those contempt proceedings. So we're just going to run through each of those steps.
So the first step, which is adding the individuals to the penal notice, has a particular challenge where the individuals are not the de jure directors of the company that has breached the order. Just to remind you, in our situation, the individuals are directors of the sole director of the company breaching the order, and that sole director is itself a company. Now, the CPR does allow a penal notice to include individual directors. The authorities indicate that to be an individual director for these purposes, you either need to be a de jure director or a de facto director, and that being a shadow director is not sufficient. So there is an important distinction for these purposes between a de facto director and a shadow director. The test for de facto directors is the most cited test. It comes from Lord Collins in the 2010 Supreme Court decision in Holland v HMRC, and he says that the relevant question is, quotes, whether the individual was part of the corporate governing structure of the company, and whether he assumed a role in those companies which imposed on him the fiduciary duties of a director. So what one is looking at here is an individual who has de facto exercised power or authority to make decisions on behalf of a company, just like the de jure directors of a company would be accustomed to do. Now, the distinction between that position, effectively de facto control, if I can use that short form, and shadow directors, is that shadow directors who are not directors of the company don't have power and authority to make decisions on behalf of the company, but they are individuals who the directors are accustomed to act on the instructions of, but cannot take steps themselves on behalf of the company. So a classic example of that would be where you have nominee directors, individual nominee directors of a company. They act on the instructions of their principal. That principal will be a shadow director, but he will not be a de facto director. Now, the question then arises, well, do these principles apply in relation to foreign companies, as we have in the Akhmedova case? And the answer is to that is yes. The decision of Mrs. Justice Mulder in the Commercial Court in Integral Petroleum v. Petrograd, that's 2018, is a decision on the point. And she says that even in respect to companies incorporated outside of this country, English law rules of attribution are to be applied to the analysis of whether the person is a de facto director of a company for the purposes of deciding whether or not a committal application can be made against such persons. So in short, if you can advance before the court a good arguable case that the individual is a de facto director of the company that breached the order, then you will be able to get permission to include them in the penal notice on the order.
Yeah.
That would be the completion of stage one.
And the types of evidence that you might look for and the types of evidence that we used in the Akhmedova case are evidence of things that only individuals can do. So we had evidence that the individuals who were the directors of the corporate director was then the director of the defendant responded in the case. Those individuals were signatories on bank accounts for the respondent. They'd signed the Articles of Association. There is correspondence by those individuals on behalf of the defendant company, not just on behalf of the corporate director that they were obviously directors of. And so in that case, Mrs. Justice Knowles accepted that if those individuals were not, who were the directors of the corporate director, were not also in control of the defendant, then it was difficult to see practically who was.
There's another aspect of the sort of extraterritoriality feature of the case, which needs to be borne in mind. I've already referred to the English law test applying to the foreign establishment. There's another question, which is, can you bring a contempt application against persons who are residents abroad? And that depends on the question of whether CPR 81 has extraterritorial effect. And that was decision was made in the Court of Appeal in Dar Al Khan real estate in 2014, where the court said, well, as a matter of construction, CPR 81 does have extraterritorial effect. And they justified that on the basis that you need to be able to have extraterritorial effect if the court is going to be able to deal with cases justly and be able to control its proceedings. Otherwise, chaos will rule.
Yeah, and
that position, I was just going to say, that position can be contrasted with, CPR 71, which deals with the court's ability to make orders in to obtain information from judgment debtors to assist in enforcement, where it was held in Masri that the provision did not have extraterritorial effect.
Yeah, I was just going to say, in the BVI, we're not aware of the case law which deals with the question of whether CPR 53 has extraterritorial effect, but we think it's likely that a similar approach would be taken, and that's because there's a strong public interest in court orders being enforced, and so that makes it more likely that a provision is going to be considered to have extraterritorial effect. I think it's fair to say that in the past there's been a fairly strong presumption against legislation having an extraterritorial effect, but there's a recent Privy Council decision called AWH and ZCM, which was an appeal from Bahamas about the extraterritorial effect of Bahamian insolvency legislation. And I think it's fair to say in that case, the Privy Council indicated that it's going to be more willing to find that legislation has extraterritorial effect because of the global nature of litigation. So I think we're just going to quickly run through now the next 3 steps. Alan, do you want to do the second?
So we've now got the individuals on the penal notice. Next stage is to serve the order on them. In relation to that, you've got to serve them personally unless the court dispenses with the need for personal service. If you're doing that through the usual route in Liechtenstein through judicial channels, it's going to take several months. You can't wait several months in order to see if they're going to comply with the order. So there is a justification for going for alternative service on them. For example, service by email, if you have an email address, which is one of the routes that was used in the Akhmedova case. One of the considerations you need to think about with personal service is whether service directly on them by handing the document to them in the country concerned, in this case Liechtenstein, would breach for the local law. If so, then you need to look for another route. And there was a potential problem with personal service by handing the document over in Liechtenstein. So the other alternative service routes followed, avoided any risk of that. So that's step 2. Step 3 is the issue of your committal application.
Yeah, so step 3 is bringing the actual contempt proceedings. So once you've got service of the freezing order with the penal notice, you can then issue your contempt application. It needs to be supported by evidence, both under the English and the BVI rules, and the requirements are set out in CPR 81 in England and CPR 53 in the BVI, and they're very similar.
So that's fairly straightforward. The final step to get the proceedings on foot is to serve your committal application under CPR 81.5, and I think that the equivalent provision in BVI is 53.7. The committal application will need to be served personally unless otherwise ordered by the court. You need permission potentially to serve out the committal application. I say potentially because under the family rules, you don't need permission. It can be served without the need for permission. That's FPR 6.41, but if you're in commercial proceedings or Chancery Division proceedings, you will need permission to serve out, and the obvious basis for doing that in respect of English proceedings is the necessary or proper party gateway. You will be bringing the committal proceedings against the company for breach and then against the individual directors as necessary or proper parties. So no difficulty there in terms of CPR, and likewise no difficulty in respect in the BVI. You would rely on the similar gateway under CPR 7.3. And in relation to service, again, you would look to justify alternative service for the same grounds as we discussed with service of the order. So that sort of sets you all up to get the application ready to be heard. What you then get is the individual directors and indeed the company seeking to preempt the committal application by applying to the court to set aside the orders that have been made for transfer and for disclosure. And that brings us to the second part of this discussion, and is going to lead off on that.
Yeah, so that's precisely what happened in the Akhmedova case. The corporate director applied to be released from its obligations under the order, and it said that it would be in breach of Liechtenstein law if it complied with that order. And so there's a decision also from Mrs. Justice Knowles about what you do in those circumstances, which are really interesting. There's a few points to make. The first one, most importantly, is that a court can order a foreign party to do something which would be a breach of foreign law. The Masry case tells us that. And the second point to make is that although an English court and BVI court will take the same approach, does not lightly make orders which require a breach of foreign law, it's not in any sense precluded from making those orders, and that's now well established. Alan, do you want to kick off with the rest of the?
Yes, I mean there was examples that we can give of the courts applying that criteria in Bank Mellat and HM Treasury, which was a Court of Appeal decision in 2019. The court recognised that it would balance the risk of prosecution against the legitimate interest which an English court was seeking to achieve by its orders. And in that case, the court concluded that it had jurisdiction to order the production of documents, regardless of the fact that compliance with the order would or might entail a breach of foreign criminal law. And there are a couple of other examples which you'll get in the paper after this talk. And it sort of follows from those 2 points, that the court can order a foreign party to do something in breach, and that the court does not lightly make the order, that the court does have a flexible discretion when it comes to whether to make such orders. The fourth point that flows from that is that the discretion will be exercised. This is the usual formula, I'm afraid, taking into account all the circumstances, and that includes the nature of the order made by the English and foreign court, the circumstances in which the relevant orders were obtained, and the consequences of breach of the foreign order and any other relevant considerations. And that list of potential factors is one which appears in Christopher Clark's judgment at first instance in Masry. The fifth point is that an order can be challenged on the grounds that it breaches principles of international comity if it is exorbitant. Comity considerations require a court to consider A, the connection of the person who is the subject of the order with the English jurisdiction, B, whether they were ordered, whether what they were ordered to do was exorbitant in terms of jurisdiction, and thirdly, whether the order had impermissible effects on foreign parties. And the authority for those points is Collins in the Court of Appeal in Masry. So in this case, in the Akhmedova case, in deciding whether a committal order should be made, or more importantly, on the variation, whether the order that had previously been made for transfer should be set aside, one of the important factors that the court needed to consider was what is the risk of either prosecution or civil liability in the event that the order was complied with by the individuals who were the de facto directors of the company required to comply with the order. And the view that Mrs. Justice Knowles took was that the risk of criminal proceedings, and it was that she was primarily concerned with, risk of such proceedings being brought in Liechtenstein was very low indeed. Indeed, she regarded it as purely hypothetical, not least because of the lack of any examples being put forward of similar situations where criminal proceedings had been brought in Liechtenstein. For example, situations where the director has disclosed information about the trust, which was potentially in breach of Liechtenstein criminal law. and weighing that factor in particular against the importance of compliance with the court orders and the importance of the orders that had been made by the court, she declined to vary the orders, not unsurprisingly, given that in her view, setting aside those orders would severely or substantially hamper the wife's ability to pursue her claim. Yeah. We've got no reason to believe that a BVI court in a similar fact situation would take a different approach.
Yeah, absolutely. I think we've got a few minutes for questions before the next talk, if anyone's got one.
May I ask a question as someone who had an early involvement in this matter?
You may.
What do you think the result would have been if the judge had found that compliance would have caused a real likelihood of criminal, a real risk of criminal prosecution in Liechtenstein for complying with the, if they complied with the English orders?
I think it's fair to say that would have been a very important factor, but it wouldn't have been determinative, because the case law makes clear that you need to balance the risk of prosecution against the legitimate interest which the English court is trying to achieve by with its orders, and that's from the Bank Malat case from last year. I think it's fair to say that the court would be more concerned if the real risk was a real risk of criminal proceedings, criminal prosecution, as opposed to civil proceedings. They'd certainly take that much more seriously, but it wouldn't be the end of the matter, but it would certainly make it more difficult.
Yes, I think that's fair.
Yeah. Okay. Well, if there are no further questions, we're going to hand over now to Tim. So Tim, you can stay on, and to Jamie, who are going to tell us about asset stripping claims and reflective loss.
Thank you.
Thanks, Liz.
Good afternoon.
Afternoon, everyone. We do have a few slides, but nothing quite as exciting as Mrs. Akhmedova's yacht. Our case involves an iron ore mine, and I didn't see any point in giving you any slides showing the iron ore mine. Jamie and I come to talk to you about asset stripping claims and reflective loss arising out of a case we're involved in Cayman called Raiffeisen Bank and Scully Royalty. And I just thought I'd outline the facts of that and how it involves asset stripping and potentially involves the principle of reflective loss. We act for a bank plaintiff in the Cayman claim, which has the benefit of guarantees. The directors of the guarantor, asset stripped, cause the guarantor to be asset stripped in such a way that the guarantor's assets were transferred to related companies controlled by the same individuals at an undervalue, we say for the purposes of putting the assets beyond the reach of our client, the creditor, who, as I say, has claims under the guarantees. So our client was interested to bring claims under the Cayman fraudulent conveyance legislation, the fraudulent dispositions law. In the BVI, this would be Section 81 of the Conveyancing and Law of Property Act 1961, and or the Fraudulent Conveyances Act 1571, Statute of Elizabeth, which Mr. Justice Jack has recently held remains in force in the BVI. So, as is often the case in an asset stripping case, where you have in England a Section 423 claim, or in Cayman an FDL claim, or in the BVI a claim under the 1961 Act or the 1571 Act, we were looking to cast the net of potential defendants and those who are liable to pay damages for the unlawful acts more widely than the immediate transferees, direct transferees of the assets who had received the assets from the guarantor. For a number of reasons, there was a large group of companies which had received the assets, who were the direct transferees, and the immediate transferees, some of which were not known about, and some of which were resident outside the Cayman jurisdiction. But the top company that had masterminded, according to our case, that had masterminded the asset stripping was a Cayman company. It had received some of the assets, but not received others. It had called but to make a claim in the tort of unlawful means conspiracy, with the unlawful means being the fraudulent conveyances at an undervalue. But we were faced with the possibility, which needed to be explained to the court on an ex parte application for a freezing order, that the defendants to the conspiracy claim might contend that the bank's tort claim was misconceived, because they might have argued that the tort claim was barred by the reflective loss principle, because the bank's loss, namely the loss of the ability to enforce its guarantees against the guarantor, was effectively the same loss as that suffered by the guarantor as a result of the unlawful acts of its directors in causing the company to be asset stripped. And our original ex parte application, and indeed the return date, took place before the judgment of the Supreme Court in Marex was handed down. And indeed the judgment of Mr. Justice Parker in the Cayman Islands was handed down a week before the Supreme Court handed down its decision in Marex. So we had to contend with the consequences of the Court of Appeal's decision in Marex. And the Court of Appeal in Marex had held that the reflective loss doctrine extended to a creditor's claim in tort for damages against the director of the debtor for asset stripping the debtor. And held that that was barred by the doctrine of reflective loss, because the damages claimed by the creditor, the same damages as those suffered by the company. Now, a substantial body of case law had developed over the past 5 or 6 years to try to sidestep the consequences, particularly in a fraud claim, of the reflective loss principle. And so exceptions had grown to apply to mandatory injunctions. So it had been held by an English decision, which we'll look at in a little bit more detail, to an English decision where a shareholder made a claim against third parties on fraud claim and applied for a mandatory injunction for the return of the assets to the company. The English court held that that didn't engage the reflective loss principle. It had been held in Cayman not to apply to a quia timis injunction application, and it had been held also not to apply to a specific performance application. And therefore, it was held to be limited to a remedy in damages to the creditor. So in our case, what we did was we included in the writ in the Cayman claim an application for relief consequent upon unlawful means conspiracy. But instead of our primary relief being in damages, we sought relief by way of injunctions to require the payment of monies by the tortfeasors and or the transferees back to the guarantor, rather than payments being made to the bank. We contended that that was relief which took the matter outside of the reflective loss rule. And to cut a very long story short, Mr. Justice Parker agreed. He gave us our ex parte freezing injunction, and after a 3-day contested hearing in January of this year, in July, he handed down judgment upholding the injunction and finding that the reflective loss principle was not engaged, and even if it was engaged, the relief claimed by us in terms of asking for transfers back to the guarantor meant that it was not a claim that ran into reflective loss problems. A week later, after that judgment, the English court released its decision in Marex. Strictly, the ratio of Marex is limited to the finding that the reflective loss principle does not apply to creditor claims, but it is a very important decision, and it's likely to have an impact on BVI cases going forward. And so Jamie is going to review it. So if we can just go to the first two of those slides. Back to the first slide, please, Jamie. So in terms of the BVI position, in summary, the Eastern Caribbean Supreme Court has to date followed English authority as to reflective loss. I'm going to be dealing with that in a little bit more detail in due course. The Marex case in the Supreme Court has had a seismic impact on the current state of English precedent, as Jamie is going to explain. We think it would have limited extent on the existing BVI precedent, and we've assumed that the BVI court will ultimately follow the Supreme Court. But it, of course, will have a significant impact on BVI going forwards. And the next slide, please, Jamie. Just to give some structure to this, Jamie is going to deal with some key takeaways from Marex in the Supreme Court. I'm going to touch upon those cases that I've referred to about the existing BVI precedent, and then we're going to have a look at some examples of the impact of it going forwards, in particular in asset stripping cases. So I'm going to hand over to Jamie now to deal with section 1.
Good afternoon. I think the headline point that I want to get across from this summary of takeaways from Marex is that, at least from the perspective of English law, this is now a fundamentally different beast to the rule against the recovery of reflective loss, or the reflective loss principle. This had come to be known in this string of English law decisions from Johnson and Gorwood in the House of Lords through to Marex in the Supreme Court. We now have a rule that is instead referred to repeatedly by the Supreme Court as the rule in Prudential. And I think the best way to explain this is through 6 ways in which the law has changed, at least English law has changed, and or in which it has not changed. And the first of these, I think, to start with, is the underlying basis of the rule itself. Now, before the Supreme Court, probably the best summary of this was actually Marex in the Court of Appeal, which had set out 4 policy bases that were said to underlie the rule. Now, those haven't completely been swept aside. The Supreme Court still referred to some of those, although not all of them, in its judgment. But it seems to me that the key basis of the rule now is summarized most pithily in that quote that I've put up on the slide. That is the unique position in which a shareholder stands in relation to his company, reflected in the rule in Foss and Harbottle. And the reason I want to start with this is because it explains quite a lot about how the impacts of this decision and some of the other points I'm going to take you to. So the way that the Supreme Court understood this rule is that it's part and parcel of the rights that a shareholder does and does not have by virtue of their being a shareholder. In other words, the shareholder is limited to the remedies that are granted to them in the company's articles or otherwise by company law, where those articles are not being followed or being abused, or otherwise in any event pursuant to a derivative action, an unfair prejudice petition, or perhaps even a petition to wind up the company. To put that another way, going forwards as a matter of English law, outside of those traditional company law remedies, all of which are unaffected by the decision of the Supreme Court, the company is to be ruled by majority and or pursuant to its articles, and that is that. So moving on to some of these other more specific and practical points that come out of this, one of the policy considerations that I mentioned where the previously were understood to govern the rule, as set out by the Court of Appeal in Marex, is the risk of double recovery. And my second point is that where you are outside of the rule, so where, as really understood by the Supreme Court, the rule in Prudential does not apply, to the claim, double recovery is going to be dealt with by the trial judge in the circumstances as he or she sees fit. What the Supreme Court has said is that there shouldn't be some kind of automatic priority on the part of the company over the claim that the shareholder might bring. Instead, there are a variety of ways the trial judge might decide to deal with this. They might decide that there's an obligation for one party to give credit to another. They might rely on other legal concepts such as subrogation. But either way, they're going to leave it for the trial judge to work out rather than set down some automatic rule at the outset. Now, where you fall within the rule, so where the rule in Prudential does apply, any such loss is irrecoverable as a matter of law. Now, that short sentence belies a number of points, which are going to be my third and fourth points. So the third point requires me to go back just a little bit to Johnson and Gore Wood, which is as the only previous decision of the House of Lords on reflective loss. There are no other decisions of the Supreme Court, and there have been no decisions of the Privy Council. And the decision in Johnson and Gore Wood was one of those extremely helpful decisions of the House of Lords where all of the Law Lords gave separate speeches and none of them agreed with each other, or at least very few of them took the time to explain how they agreed with each other or didn't. And Lord Bingham's speech had been cited in a number of subsequent decisions as setting out the relevant principles. Now, his decision has survived the Supreme Court. He's not been overruled, although all of the other speeches essentially have been. Although that's with the caveat that Lord Bingham's speech would still need to be read in light of Marex, and it may be that they have put a gloss on it, but ostensibly his speech survives. And it had been understood in a number of decisions, or at least had been submitted in a number of decisions, that Lord Bingham's summary was to the effect that if you as a shareholder could show that you had in fact suffered separate and distinct loss to the company, then you fell outside of the rule. And the Supreme Court has held that that is, to the extent that ever was the case, that is no longer the case. If you have suffered distinct loss, in fact, it is nonetheless irrecoverable as a matter of law. And we can see that because that was the disagreement between the majority and the minority. The minority in Marex in the Supreme Court would have left it open to a plaintiff to argue they had in fact suffered such loss. And the majority said, no, if you fall within the test, irrecoverable as a matter of law. The fourth point on the next slide is a shorter one. So your loss is irrecoverable as a matter of law, but it does not bar the cause of action as such. Now, there's not necessarily any immediate significance to that, but in my submission, that's one you might want to file away for future, as it may be that that will have significance in the analysis of as yet undecided issues as to how the rule works. And my fifth point is another short one. The rule remains a hard and fast rule. It's not a discretion. If the court finds that your claim is within the rule in Prudential, it must strike it out. And the last point is perhaps the most important, but I'm only going to address it very briefly because we're going to come on to it a bit more later, and Tim has already touched on it. So the Supreme, as Tim alluded to, quite a considerable body of authority had built up as setting out various exceptions to the rule, and the Supreme Court has swept all of those aside. It's explicitly held that the fraud exception, as I might call it, in Giles and Rind is no more, and it's no longer limited to claims for damages. It applies to all forms of relief. Although with the caveat, as I said, that traditional shareholder remedies fall outside of the rule in principle. And I very briefly just want to cover off a short point from this decision of Bigg and Smith, which I referred to in our bullets, which is just to say that this is a subsequent decision of the English High Court, which has already applied the decision of the Supreme Court in Marex. And it repeated and confirmed some of those points that I've just set out, some of which were submitted to be ambiguous or unclear following the decision of the Supreme Court itself. And it also notably set out a very narrow application of Marex. It held that claims by what it referred to as a second or third degree shareholder. So the plaintiff is not themselves a shareholder in the company. They're a shareholder in a shareholder in a shareholder of the company, or something like that, or a lesser or longer chain. That fell outside of the rule. The letter of what the Supreme Court said was a shareholder in a company, and that's all that was caught. And that suggests it's going to apply very narrowly going forwards, at least in the English courts. And with that, I think I'll hand back over to Tim, who's going to deal with the impact we think this will have on the BVI law as it presently stands.
Thanks, Jamie. So on this slide, we just highlight that there's no BVI decision that's considered Marex in terms. We take the view that the BVI courts are likely to ultimately follow the Supreme Court decision in Marex, as they have in the past followed Prudential and Johnson. We think that the impact on the BVI, current BVI cases, which I mentioned in a moment, would be relatively small, although there might be some tensions to resolve. If we could have the next slide, Jamie. Thanks. We've identified a handful of BVI cases where the principle has been referred to in chronological order. It'll be in our paper when it's released later this week, but these might be of interest to you. Case called Citco, CITCO, in 2009, decision of the Court of Appeal, which was a shareholder claim and an unfair prejudice claim, in which the first instance judge had cited the English law decisions in Johnson and Shaker, and the Court of Appeal didn't agree that those principles were applicable. The second case is a case called TOH in 2011, where the court held that it was established law of the BVI that a shareholder cannot sue for a wrong done to a company for reflective loss caused to its shareholdings. The third case is a case called Pleshakov in 2015, where the first instance court applied English law and the Johnson-Gourgey case, and in particular in relation to shareholder claims, holding that they weren't recoverable because they were reflective of the company's losses. And then most recently, and indeed shortly before the Supreme Court handed down the decision in Marex in July, in May 2020, a BVI case called Court of Appeal case called Fairfield Greenwich Limited, where the Court of Appeal makes no reference at all to the fact that the reflective loss doctrine is going to be reviewed by the English Supreme Court in Marex. But it cites, it's a shareholder case, and it cites and applies traditional statements of principle as applicable to shareholders in Prudential and Johnson. And I just note that at paragraph 55, applying the old perceived wisdom, it refers to the Giles and Rind exception, which, as Jamie has explained, is now OTOs. And the final case that we identified was a case called Dennis and Dickinson, a couple of days later on the 25th of May 2020, again just before the Supreme Court released the Marex decision, again applying the conventional rules to a shareholder claim. So what we have in the BVI is that all of these claims were shareholder claims, not creditor claims. To our knowledge, the Court of Appeal decision in Marex was never applied to a decision in the BVI, and the BVI court, so far as we know, has never had to grapple with any of the exceptions. Marex has not been mentioned in any of these cases, although two of them were decided while the appeal was pending. And we think that the only point that really needs to be corrected in the established authority in the BVI is the acknowledgement in the Fairfield case that the Giles and Rind exception applies, which of course is no longer good law under the Supreme Court's restatement of the principles. So as we say on the second slide on this issue, Marex hasn't arisen in the BVI courts, nor is there a body of case law on the exceptions, and Johnson has been applied, but that's not the objectionable parts of the Johnson case, and the BVI courts have taken the very line that the Supreme Court has now taken following Prudential and the rule in Foster and Harbottle. Back to you, Jamie.
So I think that brings us on to our final section, where we wanted to consider, assuming that we are right in our assumption that the Eastern Caribbean Supreme Court will follow the decision of the Supreme Court in Marex, not least as it doesn't appear that it will have an enormous impact on its existing case law, aside from those relatively minor tensions to be resolved. We want to look at the impact that might have going forwards. And as we've already referred to on a number of occasions, there is this body of case law that had developed as to potential ways around the rule if you were a plaintiff. And in this final section, Tim and I are going to consider each of us one of these and the extent to which it still applies following the decision of the Supreme Court, if that's followed. Now, that this isn't going to be an exhaustive list, and we'll consider a few more in our paper, which we're going to circulate a little later this week. And some of those options include seeking to have a friendly IP appointed over the company, and whether a special exception has been developed in the discretionary trust context. And a further potential item on that list would be a claim under Section 81 of the Conveyancing and Law of Property Act, as Tim has alluded to. But there's two we're going to cover in a little more detail, and for the first of those, I'm going to hand back to Tim, and that's on seeking relief other than damages.
Yes, so I think we're relatively tight on time, so I'm going to take this quite quickly, and I have mentioned this principle at the outset. So the principle now we know from the Supreme Court decision is not limited to claims for relief in damages. And so effectively, these authorities that on the principle that I referred to before have been overruled. So Peak, I just take for one example, Peak Hotels and Tarek was a claim where a shareholder sought a mandatory injunction, in a fraud claim, a conspiracy, unlawful means conspiracy claim against a third party, requiring the third party to deliver back the property to the company. So quite similar, although we were a creditor and they were a shareholder, but quite similar to the Raiffeisenbank and Scully case, our case. And the court accepted that the claim for a mandatory injunction was outside of the reflective loss principle. Paragraph 53 of Marex in the Supreme Court makes it clear that that understanding of the exceptions to the rule are no longer correct, no longer apply. So those are the cases: Peak Hotels, Maroil, and Zikun, which is a Queer Timmis injunction, a Cayman case, and our decision, Raiffeisenbank and Scully. So the rationale of the judge would no longer be correct, but of course, in Raiffeisenbank and Scully, as I explained, we're a creditor, so we're now completely outside of the reflective loss.
I'm going to very briefly cover off a further potential exception. Oops, sorry, I've clicked back on the slides there, which is that you may be able to argue that your claim is governed by another law, or at least that the reflective loss issue is governed by another law. And I think I've referred to the two cases there on the slide, but I think in the interest of time, and given that we've covered that in the paper, I will leave that to then. And as we said, we're going to circulate a paper, and so which will cover off these points across the talk in a little bit more detail and give some of the citations and references. But I think we might just have time for a question or two if anyone has any. Otherwise, thank you very much for listening.
Thank you very much.
Thank you. I've got a quick question, if there aren't any others. I think you very intriguingly mentioned that it was it Section 81 of the Conveyancing and Law of Property Act, so which I think is equivalent to the English provisions about transactions defrauding creditors, might be a way around the reflective loss principle. How does that work, and is it compliant with Marex?
I can take this one if you want, Tim.
I think, given that I'm having some internet problems, if you can hear this, why don't you take it, Jamie?
No, sure. So this applies, or this was one of the arguments that we made in Raiffeisen and Scully, and it was in a universe in which we were contending with Marex in the Court of Appeal. So if Marex in the Supreme Court is followed, this to some degree largely falls away, not because the line of case law has been overruled, but because the original problem is gone. if you're a creditor, the rule no longer applies to you, so you no longer need an exception. That said, we can see that a point at which it might arise is where, for example, you've got a shareholder, someone who is a shareholder, but they're claiming in their capacity as creditor, and the defendant might raise the point and say, oh, well, you're still caught by the rule. And we think that going forwards, it's likely that the courts in England, at least, and we assume the same position would be adopted in BVI if it followed the Supreme Court, for a reason I'll come on to, would hold that the shareholder could nonetheless bring that claim if they were claiming as creditor. And the reason we say that is because this is the very point that led to Marex in the Court of Appeal. Some earlier Court of Appeal decisions grappled with this point of what happens where the shareholder is also, where the creditor claim is brought by a shareholder. And this led through a series of logic to the decision of the Court of Appeal in Marex, where it also caught creditor claims. And given that the Supreme Court has overturned all of those cases, it seems to us that if this point were raised once again, the answer would be no, Pandora's box stays closed. The shareholder can bring their claim in their capacity as creditor, and that's that. So I hope that answers it. So in short, it's not been overruled, but the problem might have largely gone away, apart from in that specific fact pattern.
Yeah. Okay. Thank you very much, Tim and Jane.
I'm going to give a concurring on that.
I think that was Tim concurring. Thank you very much, Tim and Jamie.
Okay, great. Well, rather than spend 25 minutes exchanging war stories, Tom and I thought we'd do a fast and furious canter through a few practical problem questions. What links the three of them is there's an impasse in all of them, a blockage. Things have ground to a halt, and a bit of lateral thinking and elbow grease is needed to get them moving again, or in rather more legal terms, a broad use of the court's supervisory jurisdiction over trust to deal with some novel situations. And these are situations we find cropping up private trust context, sometimes with a commercial flavour, sometimes with a corporate flavour. So Tom's going to cut and paste the very short problems as we go through them, but no need to read them, because I'll just go through the basic scenario for each one. And if anyone wants to join in, we'd more than welcome it. Either join in through the chat function, thumbs up, or just come in when you want. If you don't, Tom and I will proceed to have a good back and forth between ourselves. So the three topics we're covering are firstly, a rotten apple on the trustee board, what you can do about that, which is really dealing with when you can attack the composition of trustee boards. The second is what happens when you have deadlock on a trustee board, which is an analogous situation to where you have deadlock on a corporate board. And the third is what you do as a trustee where you've got a trust with a bit of a history, which is facing a number of problems, including claims from third parties, which is something you often squarely face in the commercial context, people coming along and saying in a host of situations that the trust assets are really the product of some fraud and are really held for someone other than the beneficiaries of the written trusts. So kicking straight off with the first one, the rotten apple on the trustee board. Let's say corporate trustees got two directors, Miss X and Miss Y, and that Miss X just does not get on with the beneficiaries at all. So let's say the trustee comes up with some decision, say a decision in relation to the investment portfolio, and it's objectively a reasonable decision. But let's say it's in fact motivated by Miss X's dislike of one branch of beneficiaries. So that branch objects. The trustee says, I want to go to court and get blessing. And the hostile branch of beneficiaries applies the trustee's removal in response. So you've got a blessing application on foot, but then one branch saying in return, no, don't give blessing and remove the trustee. How does the court approach that situation of a lone rotten apple on the trustee board, and assume that there is hostile feeling on Miss X's part, and assume also that the trust's got quite a lot of institutional memory, the trustee's been there for quite a long time, has built up a useful knowledge of the trust assets and its structure. So what do you do there, Tom? I mean, possibility one, just remove the trustee, get in a new skin.
Yeah, well, that's the nuclear option, isn't it? But the problem with that is it might be seen as throwing the baby out with the bathwater, because you're losing all the good institutional knowledge that you've been talking about, and possibly a lot of the good work that's been done in formulating the the proposals in the first place. So yes, as a last resort, but I think the court's going to want to look for something more flexible if possible.
Yeah, a bit over the top. Okay, well, let me try this, a bit more flexible. Could the court just remove Miss X, remove one of the two directors of the trustee company?
Well, that's at least focusing on the real problem, but there's a big legal impediment to that, which is that the directors of the corporate trustee are a matter for the members of the trustee company. It's not for the court to be intermeddling with the operation of the company, and the members aren't even before the court. So, nice idea, but not going to work as a matter of legal nicety.
Yes, and I suppose it could also cause a problem if the trustee was trustee of a number of trusts. If you remove her from the problematic one, you've removed her from the board of the trustee for all the trusts, which is a bit, again, a sledgehammer to crack a nut. Okay, try this. Could the court condition giving blessing relief on her resigning, saying, I will do as long as she goes?
Well, you can see the initial attraction to that is that you've got a decision which is the outcome of which is on the face of it a reasonable one, and you'd be ending up with a reasonable decision and no longer the bad apple being involved. The problem with that is on a blessing, it's a binary question. The decision is either a good one that was reached properly, or it's not a good one that was reached properly. And if it was tainted by animus, there's a real risk of that, then it doesn't matter what the outcome is, it's still not right for blessing, on the ripe and bad apple analogy carrying on.
Yeah, it's binary, bad or good decision, blessed or not. Try this then, fourth time lucky. Can you reject the blessing application if you're the court, but also reject the removal application on the condition that she resign?
Yes.
Does that work?
Yes. I mean, the first thing to say is that the court is possibly unlikely to be all that enamoured by simply rejecting the blessing application out of hand. The Guernsey Court of Appeal, in a relatively recent case of Re F, spoke about the need for dialogue between the trustees and the court on blessing things. And so the court might reasonably take the view that the pressing issue is the animus and Ms. X's involvement. So park the blessing decision for the other day, for another day, and deal as a part of dialogue with what to do about Ms. X in the meantime. And could, as part of that dialogue and how to sort things out, yes, could indicate that Ms. X leaving would take the sting out of the removal side of things.
Yeah, it's quite a flexible approach, isn't it? The idea of a dialogue between the trustee and the court, quite helpful. Could Ms. X help herself by preempting this to an extent, by offering to resign if that was a difference between the court removing the trustee and not, saying, I don't think I've done anything wrong, but if you're otherwise going to remove the trustee, then in that situation, I'd agree to go. Yes,
well, it's in respect of her personally, analogous to the position that arises on removal applications more generally, where the party at threat of being removed doesn't want to be seen to be hanging on to the role, and will say, if the court thinks it's best, very, very happy to go. So yes, if she was well advised and self-aware enough to recognise that she is the problem, volunteering her own departure would be was likely to be a sensible thing to do.
How, though, do you deal with the problem that the trustee might be a trustee of multiple trusts? So if she goes from the board of one, she's lost to the board of the other trusts, even though nothing's gone wrong in relation to the other trusts.
Well, this was a question that was touched upon by the Supreme Court in Bermuda in a case called Re X, which was concerned with similar fact pattern to this, and the idea that you might get rid of the bad apple. And in that was a case where the bad apple director was tendering a resignation. But the judge in that case said obiter that if needs be, to get round this multiple boards problem, the court could direct somehow that one particular director's continued involvement with the subject trust would be detrimental to the administration of that trust. In other words, lay down the marker that they could remain a director of the trust company and deal with the other trusts, so long as that administration didn't stray into the particular trust in question. And so again, illustrative of the broad approach that can be adopted here, the flexible approach.
Yes, and the court said whether or not you offer to resign, I can indicate whether I think you staying there would be good for the trust or bad for the trust. So again, it's flexible use, isn't it? The supervisory jurisdiction, I think, to be commended, because it's helpful, isn't it, to everyone involved if the court behaves in that manner. So on a similar theme, that takes us on to the second problem, which is deadlock, often a common feature of corporate situations where you have a board that can't agree on something, but also increasingly examined in the trust context. So start with a simple problem and then move on to some more difficult and interesting ones from the subject of decisions. So start with 3 shareholders of a company. You've got one who's a trustee, and then you've got a Mr. A and a Mr. B. They all hold the third. Mr. A and B are the settlers of the trust. So the beneficiaries are some charities. And the key thing is an offer's been received for the purchase of the shares in the company that the trust owns. That goes to a shareholder's vote. So Mr. A, who's a third shareholder, remember, says, yup, he wants to sell. Mr. B says doesn't want to sell. And the trustee, let's say, the third shareholder, sides with Mr. B saying, no, I don't want to sell. So simple question, can A, who does want to sell, compel the trustee to vote with him?
Well, that's an easy one to launch us off with here. The answer is no. From the company law perspective, you can answer it on the basis that the trustee, in its capacity as member, doesn't owe duties to the other members to act in any particular way, and that's the hat they're wearing here. You'd also say that at the trustee level, Mr. A doesn't have any standing or interest to invoke the supervisory jurisdiction of the court at the trustee level. But also, and this might flow on to what we're going to talk about next, we know and we've been told that whilst the trustee's decision isn't one that somebody would be bound to take, it is a reasonable view to take. And so even if the court could be made to get interested in its supervisory jurisdiction, a bit difficult to see why it would be concerned. A fiduciary has taken a reasonable decision.
So illustrate a simple starting point, shareholders can't be normally compelled as to how they vote. Similarly, even if they were all trustees, if they'd acted reasonably within their discretion, not for the court to interfere as a starting point. But let's take some other examples to test that a bit more, which are more interesting. So say A and B are just 2 trustees and they can't agree. So let's say again that an offer's been received for the business of the company that the trust owns, and A and B can't agree, and A surrenders its discretion to the court. And let's say the court agrees with A that the sale should go ahead, and therefore directs A to vote in favour of that happening. Now, does B, who hasn't surrendered his discretion, have to vote in favour of the sale? So you've got 2 trustees, one surrenders, court tells us the one who surrendered what to do. Does the other trustee who hasn't surrendered then have to follow that? Or does that trustee retain its latitude?
Well, on sort of orthodox principles, or sort of back to first principles, you might say, and some of the older cases try to analyse it and saying, well, it depends whether there is really a deadlock here or not. If something has to be done, A or B has to be done, and one says A, the other says B, then there is a real deadlock. And in that circumstance, the court would be more minded to step in and supervise and take the decision. If, on the other hand, there's what you might sort of describe as structural deadlock or design deadlock, where it's almost like 2 keys to the nuclear suitcase, that both people need to agree to for it to be done, then the fact that one fiduciary in good faith doesn't think it should be done doesn't matter what the court might say about it. So one way of looking at it would be to say, is this a structural design deadlock or where the status quo is okay, or is it a situation where something needs to be done, the status quo isn't okay? Yeah,
good or bad deadlock. And this is a good deadlock, that you don't have to sell the company. If can't reach agreement to do so, then it will stay where it is. And the support is gained for that, isn't it, by the Jersey decision called Garnham, which has quite a subtle analysis of situations where a decision simply has to be taken one way or another, and you can't tolerate deadlock from a situation where, as you say, you need two keys to fire the weapon, and if you don't have one, then nothing happens, and that's okay. But how does that stand, though, Tom, in light of the recent Supreme Court decision in Letter-Mackey? Is this an interesting decision? Let me go through the facts, then you can answer that, Tom. So there you had a charitable company, quite a strange creature, and you had a husband and wife who were the board of directors, or called trustees, but they're board of directors, just the two of them. And you had three shareholders of the company, the husband and wife, and a third person, Dr. Letter-Mackey, per the title of the case. And the question was whether Dr. Letter-Mackey had to vote in favour of the charitable company making a large grant of 350 million. And what happened, the husband and wife surrendered their discretion, and the court felt that the grant should be made. And the question was, did Dr. Letter-Mackey, who was a shareholder, have to vote in favour of that when he hadn't surrendered his discretion? And what was found was that he was a fiduciary, that unusually charitable company shareholders are fiduciaries, and that because the court had decided that the husband and wife should exercise their discretion in favour of making the grant, then Dr. Letter-Mackey had too, because he'd been joined as a party and therefore was bound in some way. So what do you think, Tom? Does that sort of reasoning now apply in our situation, where A has surrendered its discretion, court said, yeah, you vote in favour of the sale, and B is a party?
Well, yes, it would seem to sort of ride a coach and horses through the two keys to the nuclear suitcase type argument, which is where if two fiduciaries each have a discretion to exercise, and the court exercises it on behalf of one, it suggests that the other has to go the same way, and that their own discretion is stymied simply by virtue of the fact that one fiduciary has surrendered the discretion, and the court's made the decision on their behalf. Now, it's quite a striking proposition. It's one that sort of cuts against the usual reluctance on the court to interfere with how fiduciaries exercise their discretion, unless it's bad, not the fact the court might differ. And what was striking in that case was it was common ground that fiduciaries could reasonably differ in their view as to whether or not the grant should be made. So what was it about the fact that the court had exercised discretion on behalf of the conflicted fiduciaries, or the surrendering fiduciaries, which bound those whose discretion was intact in their hands? There were two approaches. Lady Arden took a very narrow approach, saying the non-intervention principle, the idea that courts won't interfere with the exercise of discretion, is not an absolute rule, that exceptions have to be worked out in particular cases, and this was an exceptional case. Charitable company case is very exceptional jurisdiction. Narrow approach, we'll do it for this case, but the majority who followed the approach of Lord Briggs went rather wider, and they said, once the court has spoken, once the court has said what is in the best interests of the charity or the trust or whatever it might be, or the estate, everyone else is bound to get in line behind it, because not to do so would be a breach of duty. And that seems to be a proposition of quite wide application, and if so, of potentially quite striking effect. Yes,
I think what was common to the majority and and Lady Arden was that they both viewed this as a very serious problem, didn't they, for the company? A very bad situation being created by this dissension. And so to that extent, they viewed it as a bad deadlock. And I tend to think that a slightly narrower approach will be taken to applying the case, that it won't be found that just because you surrender your discretion as one fiduciary, that binds other fiduciaries who are joined.
Yeah, and the other strange fact, of course, was that Dr. Letter-Mackey was being studious in not giving away his hand, not giving any indication as to what he might do, and not making sort of warm noises that, I'll go along with what the court thinks best, or anything like that, which might have also had a play.
So you can see why the court felt that stepping in was an attractive result. I mean, and both sets of judgments are obviously very, very learned and repay close reading, but you can test it this way. I mean, take it a stage further in our trust example. Say that A and B both surrendered their discretions as trustees, and the court said, yeah, you should agree to the purchase. But say that the trustee required protector consent to a sale of the business, and the protector C was joined and didn't say one way or another, like Dr. Letamaki, what C would do. Would C be bound to act in accordance with how the court had directed A and B to act?
This again sort of goes back to is the deadlock built in here? Because you can see where you've got two trustees operating at the same level or in the same roles, what's good for one would be good for the other, and the consideration is the same. But where you have a fiduciary in a different role, a different office, that of a protector, you might think that the reason for setting it up that way is because the protector has different sets of considerations to take into account. And the fact that one fiduciary with one set of considerations, the court decides should exercise their discretion one way, might not translate to it being a breach of duty for another fiduciary, potentially with different considerations, not to act likewise. So again, probably grounds to distinguish the approach in Letamaki in slightly more complex situations like this, where you've got a protector. Yeah,
and the interesting question you raise is, does surrendering make a difference? Obviously, if the trustees hadn't surrendered, the protector could, as long as it acted properly, veto the trustee decision. But if the trustees have surrendered, does that become an option that's taken off the table? That's the unresolved question in the trust context as a result of it. Let's deal finally then with problem question 3, a trust with a history. So let's say you've got a corporate trustee that's got a fairly dormant trust on its books that's been going for a long time, and it's got 3 problems. The settlor and his wife, they're the main beneficiaries. They haven't been heard from for a long time. They can't be located and are assumed dead. So that's problem 1. Problem 2 is that if they are dead, then the only other class of beneficiaries capable of benefit are the former employees of the settlor's long defunct business, and the trustee doesn't know whether there are any such employees. That's problem 2. And then problem 3, the trustee's got a note on file from a predecessor suggesting that there might be a claim by a trustee in bankruptcy of the settlor to the trust assets. There might be a third-party fraud claim that says the assets are really the assets of a third party, not that of the trust. How does the trustee crack those nutty problems, Tom? Take them one by one.
Yes, you've got to break down what are the problems. The first problem is you don't know who your principal beneficiary is, and in order to work that out, you need to know whether or not the settlor's wife is alive or dead. We assume that the trustee has made all reasonable inquiries to try to answer that question, and will, having done so, need to decide whether it's more likely or not that she is alive or dead. And if they decide that it's more likely or not she's dead, they're going to want to get some satisfaction or some clarity or some confirmation of that, which will allow them then to proceed to benefit the employees in safety. And so the thing to do in that context would be to go to court without any defendants needing to be joined to seek a Benjamin order, but the court can confirm that you can proceed on the factual basis that the wife is dead, and therefore that you can treat the class of employees, former employees, as being the beneficiaries.
Okay, that solves problem 1. What about problem 2 then? So you're left then, let's say you get that with the class of employees. You don't know whether that's a class with no one in, lots of people in, and how you go about identifying who they are. How would you do that? Advertisements, some other route?
Well, again, in the first instance, you're going to do some practical investigations, but ultimately you're going to want to start distributing money, because this thing can't sit in your books forever. And I suspect that corporate trustee is quite keen to clear up its books, which is why the problem has come to light. And so, again, to give safety and security that somebody isn't going to come out of the woodwork and complain that you haven't distributed to them or even considered distributing to them, you're going to want to advertise for beneficiaries so as to protect yourself, and it's on a statutory jurisdiction under section 28 of the Trustee Act, which allows you to advertise in appropriate publications both in BVI and abroad, to give notice of the intention to distribute, which hopefully flushes people out of the woodwork, and even if it doesn't, will mean that you can distribute to those who you identify safely.
Yep.
There is a risk, of course, that nobody comes out at all, and so you're sitting with the trust and don't know what to do with it. Pay into court, exactly so.
But a tool of last resort, not a first resort. Okay, then lastly, and perhaps most interestingly, you have the possible third-party claim. So you sometimes find yourself as a trustee with a whiff of something bad emanating from a third party, but it hasn't really crystallized into a hostile claim yet, but you're worried that it might at some stage. What do you do about that? Because the risk is that you distribute out. I mean, let's say in our example, some employees did come forward, and then years later, the inchoate claim turns into a real one from the third party, and through something not within your knowledge, you find out that in fact, the property wasn't the trust's, it was the property of the third party, and you're stuck with liability because it said you had notice of that and therefore shouldn't have distributed. So what do you do in this situation where you've got a possible problem?
Well, first of all, you've got to take a view as to how bad it smells. If you were very bullish, you might say, from what we know of the claim, it's got no legs whatsoever, or we don't know sufficient about it that we could be deemed as being on notice of it, and so you crack on regardless. That's the bullish view. But as we know, clients in that position are rarely attracted by the bullish approach, and so they're going to want something that might give them a little bit more comfort. So what do you suggest to the nervous office holder who wants the comfort?
Apply to court for authority to distribute. That's going to likely require notice to be given to the trustee in bankruptcy, but the sort of approach to take is a put up or shut up one. Bring a claim within a certain period, or I should be able to distribute it out. Or if you think the claim's really weak, just ask for authority to distribute out because there's absolutely no claim at all there.
Yes, very good.
Yeah, I should say there are a number of cases from different jurisdictions on that, sometimes grouped under Guardian Trust Principle, sometimes grouped under Re Benjamin, but that neatly leads on to the closing point, which is, Tom, you're going to have indeed generated a list of cases backing the problems that we've discussed, and they'll be sent round
they
later.
will get sent round indeed.
So thanks everyone for listening.
And I think Liz is going to take back over now, is she? Yeah.
Yes. Thanks very much, Jonathan and Tom, for your very interesting discussion. I was going to give you a question about letter marking, but I think given the time, we'll probably move on. So thank you everyone very much for attending. We're going to follow up later this week with papers, which will give you an overview of all the talks and discussions that you've had today. We're going to begin the virtual networking shortly.